just feel free. I'm going to try to pull my chat up so I can actually see it in case anybody has anything there. And then we'll get started. The new docs, yes, Linda, you had a question there already. The new docs, as I understand it, are October 1st. They should be available in transaction desk, SkySlope forms, all this forms program, zip forms, any, I don't know if anybody's still using that, but if they are, they will be available in all of those. So my understanding is October 1st, so Saturday. All right, I'm trying to get my screen so I can see everything now, guys. So, obviously the first page, and this is going to, some of these are going to be some basic things, but it's just really important. I feel like, you've heard me say this before, but DocuSign is, and digital signatures have made it so we don't always sit down with our clients and actually explain all of these things. And so I think it's really important to do that, whether you're doing it digital, in electronic signatures, or you sit down with them, but somehow get on a Zoom with them or on the phone and start going through these contracts very closely and very carefully, because it's real powerful when you go back to them later when something kind of might be going a little sideways, and you can say, remember when we talked about this, or remember when I pointed out this in the contract. So I think, bold letters, big block letters, and attention buyer, I mean, it tells you something. That's an important page to cover with each of these sections with your buyers. So, I'm not going to go through each of those, but I just feel like it's don't just gloss over some of these things. I really encourage you to stop and take the time to go through it. Linda, I'm seeing a question. Do we need to get our current sellers to redo their existing spuds to the new spuds? Not yet. The new spuds, I don't believe, come out until February, actually. So I don't think those ones are out yet for everybody. I was just kind of giving you guys a heads up what was coming on that. So those are not out till February. So the first page of the contract, pretty basic, obviously, I think everybody knows, but this is kind of your essential terms, if you will. So it's really important not to miss the basics, making sure that you have correct names spelled out. And if they don't fit because it's a long, trust name or something of that nature, see additional terms and refer them to the lines later in the contract where you have that space to spell it out. But don't just abbreviate or do those things, because, I mean, if you don't have the correct people and authorized signers and signing the way they need to sign, you could have an unenforceable contract. And I have heard stories where when things got a little sideways, that was a loophole that maybe a buyer or seller used to get out of the contract because it wasn't done properly with the names. So it's really important. I got a couple of people more coming back in here. So again, if on these lines 1 and 2, you don't have that space, refer to lines 344 down and on page 8 there and spell it out if you need to, because that comes up a lot nowadays, especially with so many people have these long trust names and they're, they don't fit always. So remembering obviously to fill in that legal description, your assessor's number, just some basics there. Obviously full purchase price, earnest money. And then be clear with the financing. I'm seeing a lot of contracts come through lately where it's just got the numbers calculated out and it's not entirely clear where the funds are coming from or what's being used or how they're being paid. So be really clear when you're spelling that out on line 12 or 13, depending with how much they're putting down and what's being applied and what type of financing and what will happen at close of escrow. You guys see it a lot, but I flagged lines 17 and 18. Be very careful with filling those out, because I can tell you the one thing, when the department comes in and audits our files and our contracts, they look very specifically, did we follow the written instruction regarding the money? That's the one thing they're very concerned about. So making sure that you have those filled out properly and that it's executed the same way and followed through is really important. And for those that might be a little bit newer, earnest money is to be deposited immediately. And obviously that's a little bit subjective, but that means in essence, really the next business day. So if it's a Friday night, it needs to be in there Monday. If, you know, maybe one day leeway if you have someone who's out of state or you have these extenuating circumstances getting funds over to the title company, but it really should be the next business day. Those funds need to be deposited. If it's an all cash sale, this says that the proof of funds is attached. It doesn't say will be, and if it's not and you don't have available, if you're representing a buyer who doesn't have that proof of funds ready, then you need to spell that out in the additional terms that contrary to those lines, proof of funds will be provided within how many days, that sort of thing. And then if you are on the seller side and receive an offer that's all cash, make sure you're getting that. And I've cautioned this before, but be careful, particularly in the last couple of months, if those funds are coming from a retirement account or an IRA or any kind of, you know, stocks or anything like that, because what used to be there may not still be there, that amount. So you want to make sure that those are converted or into an account that they have readily available if possible. So Andre had a question on line 17. If a buyer changes their mind to wire from the check, to wire instead of sending a check, should you do an addendum? I would say yes, because again, we want those to match up. When the department looks, they're going to check these lines of the contract, then they're going to check the deposit receipt, and they will question if those funds are not deposited immediately. The last audit we had, they questioned me, and I had to pull out a calendar for all of them that were about 3 days. So I had to show them, or if it was like 4 days and because there was a holiday in there, I had to go back a couple of years, show them that on that particular year that, you know, this is why those weren't deposited immediately, if you will. But yes, I would say to be clear, an addendum is always the best route. And yes, I have seen it TBD, and I do think that's probably okay, Christy. Her question was, can line 17 be checked other with TBD written in if buyer wants to decide down the road? Yes, but I would say, yeah, that's fine. That's fine. I do see that a lot because sometimes they're not entirely sure what's going to be easiest or fastest or where they're going to be to get that wire out or a check, depending. Close of escrow, I think, is pretty clear. I would say on the possession side, because post-possessions, obviously in the last, you know, couple of years have been a big deal. Lately, not as much. But I do want to point out that, you know, I have flagged many post-possession or pre-possession agreements because they didn't have that statutory language that says the brokers recommend that the parties seek counsel and insurance and tax and accounting professionals and all of that legal counsel that they should be seeking in those cases. It is in here in the contract. So technically, yes, you're probably covered if it's not in that separate agreement, but I'm going to share with you, I don't think it's enough. I think you would need to have them initial this because it gets glossed over. And I think if you're doing that and it's not in your separate agreement, then you should at least have them go back and initial those lines 34 and 35 right there. Does that make sense? In your addenda incorporated, I just want to point out, these are all addendums or additions to the contract. And I see a lot of people write in agency, market conditions, forms like that. Those are disclosures. They're not necessarily addendum. I mean, those are really more a disclosure to your client from you as the agent. It's not that you can't put them here, but as soon as you attach them to the contract, all of the parties need to sign them, not just your client. So kind of keep that in mind. It's not bad. It's just not necessary to include them there. And if you do, then you have to go through those extra steps of getting everybody to sign it. Does that make sense? So just one thing there. Fixtures and personal property, I think it's really important, particularly with sellers, to go through this very carefully, and with buyers. If there is something that you're just not sure about, spell it out in the additional in line 61, 60 to 62 there, or in the additional terms on page 8, because I think, you know, it's always things like that big piece of pottery, you know, that's like a 4-foot landscaping piece or something that can be in question, or maybe sometimes the pool equipment. You know, if you've not run into it before, sometimes that pool equipment can be leased, especially when you see some of those saltwater features. those can be leased. They're not always owned. So you want to make sure you're clarifying right at the time of contract what's included so that the buyer's expectations are met and the seller knows what they can and can't take. It's just really critical because I can't tell you how many issues that creates after close when they've moved out and things are gone and someone's upset that they didn't get what they thought they were getting. Leased items, obviously seller is required to send notice of all the leased items within 3 days of contract acceptance, and then the buyer has the 5 days or the inspection period to review those and make sure they're comfortable with all of those things. Financing section. I'm going to share with you guys a couple of things in this, a couple of things that have come up recently that were really interesting to me. So again, it doesn't say that the AAR pre-qual is coming or will come. It says is attached. It is included with the contract. So it's really important you get that. I think representing a seller, there's things on there where, you know, you might catch that maybe there's a contingency in there that they didn't include a buyer contingency addendum, but it's checked the box on that pre-qual that says that they're relying on the sale or lease of another property. I've seen that happen, and it's really important to read those pre-quals very carefully and do your due diligence if you're representing a seller to investigate and call that lender and make sure that everything is what it needs to be for that buyer and that they are good and solid. The loan contingency, obviously the buyer needs to sign the 3 days prior, and then the unfulfilled loan contingency has to be delivered 3 days prior. I did have a situation I just found out about. Wasn't our transaction, thankfully, but I just want to share it because it was really interesting to me. And I personally don't think it's correct. And I believe from what I'm understanding that the legal hotline agrees with me that it's the decision that was made by the title company wasn't correct. And here's what happened. Buyer signs 3 days prior to close. They do exactly what they're supposed to do. Everything's cruising along. The day of closing, they go to fund. The lender pulls one last credit or somehow does a verification of, I think it was a verification of employment, and finds out the buyer lost their job that day or the day before. Right at close, they'd already signed, everyone was good. They can't close. Seller issues a cure notice for failure to close. Buyer issues an unfulfilled loan contingency, and title gives the money back to the seller and releases it, saying that their argument was on line 76 is that this contract shall be canceled and buyer entitled to, buyer is unable to, shall be entitled to return their earnest money if after diligent and good faith effort, buyer is unable to obtain loan approval without prior to doc conditions and delivers notice of inability no later than 3 days prior to close of escrow. And that's what the title company hung their hat on, because the buyer didn't deliver it 3 days prior. They actually signed the docs. They released the money to the seller. I don't think that's correct, but it's something to be aware of. If you get down to closing and you ever have something like that come up, we probably need to address it right away. So 83 to 86, sometimes and particularly lately, this is especially earlier this year when rates did their initial jump is very important. We were seeing a lot of unfulfilled loan contingencies come through. And of course that form, you just have to check the box. You don't have to provide a denial letter. You don't have to provide any information, but this does say that the buyer's failure to have the down payment or other funds necessary or to lock their interest rate by separate agreement is not an unfulfilled loan contingency. So that is a potential breach if the buyer's unable to close because they don't have the funds necessary. They went out and bought a car, or they didn't get those gift funds, or they failed to lock their rate and now the rates have gone up and they don't qualify. That is not an unfulfilled loan contingency. So I saw a lot of the unfulfilled loan contingencies being contested, particularly when the rates jumped up this year and buyers hadn't locked and all of a sudden panicked and decided they couldn't afford it or couldn't qualify in some cases. So just something to be careful of there and to be aware of. LSU is buyer shall deliver seller LSU with lines 1 through 40 completed. One thing I want to point out on the LSU is, some of you that have been around have heard me say this a million times, but it doesn't say the lender shall deliver to seller. It says the buyer shall deliver to seller the LSU. And so we get a lot of pushback sometimes where it's an out-of-state lender or particular banks that don't want to fill out our AAR pre-qual or LSU or pre-qual. But it doesn't say that they will. it says the buyer will. So the buyer is responsible for that regardless of the lender. So, I just want to point that out, that the buyer still has to complete it and sign it regardless if their lender does or not. And if you're not getting that on the seller side, then you need to cure. I think it's the right thing to do. It's not a negative to cure somebody for those types of things. It's just doing what you're doing to protect your seller. So just wanted to point that out real quick. Loan application, loan processing, type of financing. I want to share with you guys on this. Hard money or cash. If it's a hard money and they are writing it as cash, they're responsible for having that money, whether they get it or not. If they don't fill in the other box there on line 97, essentially right in here, if you guys can see my mouse moving, what I have seen is hard money loans written in there, and they're still doing appraisals. They still have to qualify for that hard money loan. There's some things that they need to get. So just hard money doesn't always equal cash. So just keep that in mind. We also, if you guys have ever been in this situation where a buyer writes the contract with conventional financing, and then they switch to FHA or maybe even VA down the road, and they can still close. So lines 103 to 106 there say that those changes will only need seller's consent if they do not adversely affect the buyer's ability to obtain loan approval, increase seller's costs, or delay close of escrow. So some of those changes don't do any of those things, so they don't have to have the seller's consent. So if that's a concern when you're representing a seller, that they stay with conventional financing and they're not switching, then you can write that in. Sorry, you guys, I'm gonna let a couple of new people in here. There we go. I think we got them. You can write that in, that the buyer, in your additional terms or a counteroffer, that the buyer is not allowed to change their type of financing. And just make it clear, if you say you're going to go conventional, you are going to go conventional. You're not going to flip to FHA, regardless of those changes that you're allowed to make. So we have a couple agents that just do that. They counter that almost automatically on their contracts, because as we know, FHA can create things we don't expect down the road in terms of repairs or things. So it's something to think about there. Appraisal contingency. Once that appraisal, first of all, I should clarify, I always want to point this out, that the appraisal contingency is, if you read it, it's contingent upon the appraisal of the premises acceptable to lender for at least the purchase price. So it doesn't say what happens if there's conditions on that appraisal. The appraiser notes that the roof needs a roof cert, or that there's some conditions in terms of repairs or something to the property. And that becomes a very negotiable item. The other part is that the buyer has 5 days after notice of the appraised value to cancel the contract and receive their earnest money back, or the appraisal contingency is waived. And it's important to know that you have to negotiate. If you have an appraisal that comes in under value, you need to get all that negotiation done within that 5 days. Otherwise, it doesn't matter what everybody has verbally talked about or emailed about. If you don't have an addendum changing that purchase price to maybe the appraised value, that buyer is potentially coming in with that difference. And again, if they are cash, the additional clause addendum has verbiage in there that they can still have an appraisal contingency, even if they're a cash buyer. Conversely, they have the shortfall agreements and the waiver in there if it's a financed buyer who says, I don't care, I'll pay whatever for the difference if that appraisal comes in low. Other thing for some of the new folks to always keep in mind is that it does not matter, and this was not as common now in the market we're in now that we've kind of shifted back to a more balanced market, but in the last couple of years, the appraisal can be waived if they're VA or FHA, but they will always get their earnest money back if they choose to cancel. They can't waive it entirely because that is federal law. So that last line on line 110 says, unless otherwise prohibited by federal law. So they will always get it back on FHA or VA if that appraisal comes in low and they choose to exercise their option to cancel. Appraisal costs, just being careful there to note who's paying for what. I see that come through blank a lot of times. I think everybody just kind of sometimes assumes it's the buyer paying for their loan costs as an appraisal cost, but that is a negotiable term. So making sure you fill out lines 111 to 114 carefully there. Escrow and title company, I think that's pretty basic. You all know that. One thing in lines 120 to 122, if buyer is married and intends to take title as his or her sole and separate, a disclaimer deed may be required. A lot of times, if you're aware of that, I would recommend putting a time frame on that when that disclaimer deed is to be done during maybe the inspection period or within so many days, because I think we all know there's times where we have parties that, you know, maybe it's a divorce situation or something that's a little more sensitive, and you have one party that might dig in their heels and say, I'm not signing that for the other, for my ex-spouse or whoever it is. So I think it's really important to maybe, if you are aware that it's only one party purchasing, but they are married, that you get a disclaimer deed, that you put a time frame on that when that's to the title company and completed. Title commitment, CC&Rs. For those that are new, be very, very careful that when the title company sends you the CC&Rs and the prelim, you need to make sure that your buyer has that, because that clock starts ticking when you receive it, regardless if they've received it. So sometimes if that's sitting in your email for a couple days and you don't realize it, that clock is ticking, and you may be using up the buyer's time to review that. And if they find something, they can't park their work truck out front, or whatever the situation is with the CC&Rs, or the title commitment has some judgments or something that comes up, or some easements somebody wasn't aware of, they may lose that option to cancel if you don't get that to them right away and get that reviewed. It's really critical. And I think it's something that gets overlooked. You know, if you're newer and you haven't taken a class on that, or you want to sit down and I can show you how to go through a title report and some of those things, you know, I'd be happy to do that, or I can hook you up with the title person and we can have them sit down with you. But I think that's really critical. Linda, you had a comment. I've had agents tell me lenders create the disclaimer deed. Huh. No idea. I have to educate them why I'm putting a time frame on it, as title has no time frame. Correct. That's, yeah. Agents, the lenders create? That would be a title thing. That would be the title company. Yes, Andre, the title commit is a contingency. Exactly. They have that 5 days to review it, and it's very important. And I think there's some agents that don't realize how critical that is. Additional instructions. The contract itself is the instructions to the title company. Those are your escrow instructions. So if it's not in writing, it's not something they're going to do. They have to follow it per the contract. Tax prorations, all of this is pretty basic. And the one thing in the release of earnest money I want to point out is, ultimately, regardless of what we all think or know to be in the contract, in the end, if there's a dispute on earnest money and the parties cannot come to an agreement, the title company does have the sole discretion to release those funds. So in that case, I was mentioning about that unfulfilled loan contingency a little while ago. In that case, the title company released it, and there's not a whole lot everyone can do. Now, I am seeing in the last few years an increase in title companies who don't like making that decision, particularly when it's a large amount. They kind of throw their hands up and say, we're not doing anything with these funds until the parties mediate and come to a decision between them. So, and they have the right to do that as well. So sometimes you'll see those funds sit there until the parties go to a mediation arbitration and get that worked out between them. And then they have to bring that back to the title company, and then it's released. So assessment liens and CFDs. I actually have a website, and Peoria has a new one. So that you can look up, because I know Peoria has, I believe, at least 3 CFDs. You know, you have the one in Buckeye, you have Festival, that kind of reaches around in the West Valley here, but Peoria also has 3 separate CFDs that I don't know if everybody's aware of. So I'll put out that in a broker blast. I'll send you the links to where you can find those to make sure that those are getting addressed if needed. So if it's something that's being paid for outside of just your taxes and your property taxes. So section 4, I'm just going to point this out, and section 6. I like to refer to section 4 as the seller section, if you will. And then section 6 as the buyer section. And the reason I say that is because section 4 of the contract here, if you look at it, it's everything that the seller has to provide the buyer in terms of disclosure and things that the seller is responsible to notify the buyer about. So their insurance history, the seller's property disclosure statement, obviously, it addresses the seller's obligations for FERPTA here if the seller is a non-resident alien or not a U.S. citizen. It's the lead paint disclosure is right there. And then affidavit of disclosure. And one thing with affidavit of disclosure that I always like to point out is that is not just land. A lot of times people get that in their head that it's just related to land that's in an unincorporated area, but it's not. It can have a dwelling on it and it would still be required. So, if anybody has questions on that, if you're new or you're not real familiar with what that means or what that is, let me know. It's basically just a seller's disclosure statement because it talks about wells and different things on that land and access and things when it's unincorporated. And then changes during escrow. So if, for example, we've had it happen where a monsoon storm comes through, we're past the inspection period and a tree comes down, and does some damage or needs to be replaced. That would be something that the seller would then have to notify the buyer. The buyer would then have 5 days to disapprove or approve that. I'm going to skip section 5 for a second, and I'm going to go down to section 6. When I say this is the buyer section, the reason I say that is because now that the buyer has all of that from the seller, these are all the things that the buyer needs to do with that information and investigate. Due diligence, it's kind of self-explanatory, but it's all the things the buyer needs to investigate. And I still get from even very experienced agents comments about, and I still see it on a Binzer where the buyer waives the inspection, but doesn't sign that section above on the Binzer where they're acknowledging all the other things that they were supposed to investigate, and they're still accepting the premises. What I see is they checkbox that's on the first page that says premises accepted, and then they skip to that second page, sign the waiver, and think they're good. Well, I want them to sign that acknowledgement that they have done all of their other due diligence. The due diligence period is not just a home inspection or a termite inspection. It's all the other things that they should be investigating. It's the traffic, the neighborhood, the schools, if that's important, crime statistics, anything that's related to that property. And if you read line 215, investigation to determine the value and the condition of the premises. So it's suitability. Maybe they determine that it's got some stairs that they can't navigate or have trouble. They've got maybe some family that are having trouble navigating that. It's all of the things, not just a home inspection. So I just want to make that and drive that point home. It's really important that the buyers understand that and they do all of that investigation during that time. So, and reviewing seller's disclosure statement, all the documents the seller has then provided them on their obligations in section 4 there. So I just wanted to kind of jump forward to that. In terms of the warranties, I think it's pretty clear that we have an as-is contract now. One change that is coming, Linda, now that we have this red line one, because she asked me for this yesterday and I didn't see they'd already released it, but they have changed the Binzer negotiations, as I've mentioned in a couple broker blasts, where now the seller has or the buyer has the opportunity to request a credit or have the repairs addressed versus just repaired or corrected. So in our old contract or our current contract until Saturday, it's just the buyer has the option to ask the seller to repair or correct items they disapprove of. Now in our new one, they'll have the ability to address it, meaning they can say, in lieu of those repairs, I would request a credit of $1,000 to cover them or whatever that amount is. We'll go through that a little further and a little bit down the road here, but I just wanted to point that out that they have added that change here as well. Buyer is obligated to disclose if they cannot perform for some reason. So if during escrow you were representing a buyer and you find out that they have had a change in their job, which, backing up to my unfulfilled loan contingency story, may have been the reason the seller was awarded the money. There may have been something the buyer didn't disclose there. I don't know. But if that were to happen, the buyer's made aware, they are obligated to disclose that, and you as an agent are obligated to disclose it whether the client does or not. So if it's material, it's really important that that's disclosed. Warranties that survive, seller warrants they've disclosed all material and latent conditions and defects. You know, we get a lot of, and particularly the last couple of years, a lot of calls after closing, month, a week, sometimes 2 or 3 months after closing, where something's gone wrong with the house and the buyer comes back and says, seller didn't tell me. And the first thing we always kind of try to discover is that something the seller actually knew about? Because they can only disclose what they know. And if they didn't know it, then even though maybe it was there, if they didn't know it was there, it's not necessarily something they have to disclose, because if they weren't aware of it. So I just want to share that piece with you. Let's see. I always recommend on line 211 here, by the way, when you're writing the contract, to write in none if there is no verbal. I've seen people write in verbal representations there. I've seen them write in specific terms that were discussed that they want the buyer to rely on. But if there are not any, write in none so that it's clear. I see those left blank a lot, but I think it's important to be very clear that the buyer has understanding that any verbal representations are not relied upon. And I'm going to kind of scroll down. This is all section 6, but I'm going to kind of jump down to the new parts that are redlined here. And this is where it's to correct, repair, correct, or address, meaning now they do have the option, or as of Saturday, we'll have the option to address those repairs versus simply repair them. They can offer a credit or do something else there. I have a feeling this is going to, we're going to feel a few bumps and bruises along the way as everybody adjusts to, because I feel like address is a very open-ended term, in my opinion. There was a lot of debate about it when they changed the BINSR in the contract to include that language. It's very broad, in my opinion. And I fear, just between all of us, things like buyers requesting a seller to investigate something further. So I see that the roof is, got cracked tiles, but I want you to prove to me that the underlayment is still good. Or I'm trying to think, or I saw that in the wall where there was maybe some past water damage or a leak or something, but I want you to prove to me now, address the fact that that's been repaired behind the wall or whatever it is. So I'm a little concerned. We'll see how it all plays out. It's going to be, we'll just have to see how everybody uses that language as we go here, now that it's new. It's the first time they've ever included that option. And in the BINSR, and I'm just going to go into this a little bit more. I'm going to talk about it more next week as well. But, the one thing to always keep in mind when you're addressing repairs and maybe you're asking for a credit is whether or not the buyer can receive that credit. If they're getting financing and they've already got concessions coming, they may not be able to receive a $20,000 credit for the roof repair. And then you're going to need to adjust things like maybe the purchase price. Maybe you adjust the purchase price, but again, things to consider. Now your percentages or, commissions change with that purchase price change, those kind of things. Your lender may have to go back into underwriting. I mean, there's all these things that can be a follow-up to just doing a credit or a price change. It's not always just that simple. So it's really important as you're negotiating these in the future, similar as you've been writing them in the past, to make sure you're addressing all those things before you sign off on that addendum and have everybody have an expectation that can't be met. Does that make sense? Buyer's failure to give notice of is their election to proceed without any correction of the disapproved items. One thing that sometimes people have confusion about is that if the seller doesn't respond to a BINSR, so in this section here, buyer sends the seller a notice of a BINSR, seller just doesn't respond. 5 days go by or whatever day is written in and they just don't send anything back. That essentially is saying I'm doing nothing as a seller. So the buyer needs to be aware of that. Sometimes there's some confusion that they think that means the seller has to do everything, and that is just not the case. So I just want to make sure that's very clear. Sewer line scopes, Linda noted that the sewer line scopes are becoming more common. That's very true. She had a plumber tell her that they did a scope and sewer line was bowed down 10 feet, 10 inches. Buyer backed out. Requires going into the foundation to replace that section. Yeah, and particularly in your neighborhoods that are a little older. I live out in Litchfield Park. My neighbor had a terrible situation with their sewer line. Sun Cities, some of those areas where you have some of the older homes and that's not been addressed. That's really critical to get, I agree, to get that sewer line scope done. Because that can be a very costly repair. And just a side note to that, in particular, the city maintains it up to the front of, the front yard of the lot line essentially, and your homeowner's insurance will likely take care of it in the house, but that line in the yard may not have coverage. So on your homeowner's insurance, so if something does go wrong down the road, it can be very expensive. Home warranty plan, I think that's pretty self-explanatory there. And Mary says, Linda and I had that happen with sewer line on my house in West Swing, $5,000 to correct. Yeah, it can be, it's never a cheap one, that's for sure. Walkthroughs and inspections. So this basically says, in essence, that the buyer has the right to do them. The seller will make the premises available for all inspections. They'll have utilities on, those kind of things. If you get to a property or you're aware that the utilities are not on when you're writing an offer for a buyer, build in some time for that. Maybe the inspection period doesn't start until you've gotten confirmation that all of the utilities are on. Gas tends to be one that used to be left off a lot if that house is vacant. So, it's something to think about that you could maybe proactively address before you find out. And now you've got 4 days left in your inspection period and the seller's not agreeing to extend it. I mean, you could get into everybody kind of knocking heads on that. So, be careful to check that out as you're writing the offers and maybe address it right up front. And again, this section 6 being the buyer's section, this now talks about FERPTA again with the buyer's responsibilities. So it addresses it from the seller side. Here's what the seller needs to do. Here's what the buyer needs to do now that they have that information. The cure period, the dreaded cure period. It is a pretty common misconception that when someone doesn't do what they're supposed to do in the contract, it's a breach. It is not a breach until you've given them the opportunity to correct it. So the cure period, cure notice, allows them 3 days to make it right. And you can have multiple cure notices and you can have cure notices back and forth between the parties. But it is not a breach until that 3 days end and someone hasn't done what they're supposed to do. I think it's gotten a little bit better over the years, but I still think there's a little bit of a stigma with cure notices that it's this kind of adversarial relationship and it's everybody gets grumpy about it when they get it. And it's not, it's just saying, hey, you had a deadline, you missed that deadline. Can you please get it done? And if you're not doing that for your client and representing them, and maybe something does go pretty sideways down and it goes maybe a whole lot worse, the first thing they're going to do is, as an agent, they're going to point back and say, why didn't you tell me that I had the option to cure them for that? And why did we wait a week after that it was due to ask for that pre-qual or the LSU or whatever it is that hasn't been provided as needed? So I just think it's, Andre, please clarify timing with cure notice dates. So it's always 3 days. They're always calendar days. It's 11:59 or 12:01 a.m. or 12 a.m. to 11:59 p.m. And it's every party has until the end of that day, whatever it is. So I'm going to use a close date, for example. So say you're supposed to close October 1st, if say it was on a weekday, and they don't close October 1st, even though that recorder's office, this has changed, by the way, even though the recorder's office isn't open after 5 o'clock and they can't close a buyer, a seller still has to wait till 12:01 a.m. on the 2nd to issue that cure. The buyer still has that whole day to fulfill that. So if you don't receive the pre-qual, the LSU, whatever it is on whatever day you're supposed to give it, you have to give them that full day to get it. And then you can cure them the next day. And then it's 3 days. The clock is ticking. After that 3 days has expired, then you could potentially issue a notice of breach and make a demand for the earnest money. Does that help, Andre? Is that what you're asking for there? If the cure notice is served on the close date, it depends on what they wrote as the cure. what it is they're carrying. If they're saying it's a failure to close escrow, it's not valid until that next day. The seller or the buyer would still have, if it's a seller issuing it, for example, would still have the 3 days post. So it will be the second in the example I used. Does that make sense? And it doesn't, keep in mind, everything, and we'll get there a little bit further, everything is based on delivery. So someone could sign it on the close date, but not deliver it until the next day. And that would be valid regardless of when they signed it. So they could sign it, get it ready, and then just not send it to the other party till the next day, and that would be fine. It doesn't make it invalid just because they signed it early. It's when it's delivered, if that makes sense. And then the breach is that the seller has the option to accept earnest money. Sometimes that's, people think that's just a given. It's not. The way that reads is the seller has the option and may accept the earnest money. They can also pursue a buyer for damages if they feel like they've been harmed further than what the earnest money was. Say it was $1,000 earnest money and they feel like they lost $5,000 for whatever reason because of the market or whatever the situation was. They could potentially pursue a buyer for more than that. But the buyer always just accepts their earnest money back. Alternative dispute, it says that the parties, if there is a dispute relating to this contract or arising out of, so sometimes after the fact, when we get those calls after closing where there's a dispute and they say, you know, they should have told me or they shouldn't have, or I have this wrong with the house and it wasn't disclosed, whatever that situation is, we refer people back to this and remember that we are not, our agency ends at close of escrow. So we refer them back to this section and say, here's arising out of this contract, here are your options. And we refer them back to the mediation, arbitration, and or potential litigation if that's where they decide to go. Yeah, Linda's comment was the contract should say cure period is 3 calendar days. They basically, and I'll skip forward a little bit to show you here. It says on lines 409, all reference to days in this contract shall be calendar days. So they kind of do it as a blanket so everybody's clear. I'm trying to, let me look and see if it says, yeah, within 3 days, I see where you could, but I think that's, everybody relies on that boilerplate language that it's 3 calendar days. So I agree, maybe they could be more clear there, but I agreed. And she says everyone's not clear. What would it take to just put 3 calendar days? We could submit that to the forms committee and have them as a suggestion. We can certainly do that. Let's see, additional terms and conditions. When they changed our contract the last round, you know, it was, everybody looked at this one, oh my gosh, please don't fill in these lines because that's a nightmare. If you're writing your own terms, be very clear. If you're writing additional terms, if you are changing a term that's already in the contract or amending it, make sure you reference that line so that it's clear. Contrary to line 18, buyer is going to be depositing earnest money at X or whatever, or within so many days, whatever it is that you're changing, reference the line so that it's clear, because you could, if you don't, you could have these conflicting terms in there. Other things that I see in here that are a huge concern are on or before close dates. It's really not a valid term. It can be something you put in an email to say, hey, you know, upon mutual agreement down the road, we all agreed to do that, but it just adding on or before leaves it very open-ended, very ambiguous, and it does create conflicting terms and could be a concern. AAR really tells us to avoid that because they've had issues where one party is ready to close and the other one is not. And because that was in there, now it's what really, who is right or who's wrong. So you have these conflicting terms, and then it, you know, what happens, it ends up with a lawyer somewhere. So, so just be very careful with that. I tend to say always when you're writing in an additional term and it's something that is a little different, maybe it's an escalation clause or something that's maybe a little bit different and not very boilerplate, if you will. I recommend finding someone who is not in real estate at all, reading it to them. Don't tell them any background and saying, well, how would you understand that if that was a term you agreed to? And the reason is because sometimes we in real estate can get very comfortable with the terms and we think the intentions are clear. and they are not to someone who's not in real estate, or the language that we're using or the verbiage and the terms and the, spuds and bins are, they don't know what that is. We need to explain what those stand for and what they mean. So I just suggest always running that language if you're going to write something in past someone who's not in real estate, because that gives you a very clear view, because they may tell you, well, that means this, and that was not at all your intention. So just a tip there. Always remember to write in familial relationships if you're an owner agent or the other party is, and that, just better to put it in there, so that, because the more you can address to as a buyer's agent to avoid having to have the seller counter you, the better. Because as soon as, if they had in the private remarks, for example, of MLS, and it says, seller is related to, listing agent or something, and you don't include it here, you're just giving them an excuse to counter your offer, because now they have to put it in that counter offer to disclose to you properly. So if you can address those kind of things up front and avoid that, I mean, it's just a chance that, well, they already covered it and we're not going to counter that one little thing now, maybe they won't. It's just a thought. So all the boilerplate, which may not seem important and sometimes just gets skirted over, but there's some important language in here. Risk of loss. What happens if a monsoon comes or a microburst and blows the roof off during escrow? This talks about what happens. The Arizona law, I think that's pretty basic. Time is of the essence. Counterparts. The only thing that cannot be signed in counterpart ever, everything can be except the lead paint disclosure. That is one document you can never sign in counterpart. Has to be both parties signing the same disclosure and acceptance there. Counteroffers, addendums, contracts, they can all be signed in counterpart, but not lead paint. All days we talked about are all calendar days, and it talks about the time frame there. There used to be, we mentioned it with the close of escrow, because the recorder's office is not open after 5 o'clock, that was sometimes an argument. It's not anymore. They're saying just don't send it till the next day to be very safe. I kind of glossed over, sorry, compensation. This talks about how, and I'll go back to your question in a second here, Andre, that compensation is to be delivered to the title company, that they're supposed to be doing it. They, again, are using our escrow instructions. So anything in writing to them is going to be disclosed to everybody, but this is where the commissions come in. And just because they're paying them on behalf of the brokers involved. It is not that the title company is paying it, it's that they're doing it on behalf of someone else. So just always keep that in mind. Andre's question was back to cure notice for late closing. What if the third calendar date falls on a Sunday when title is closed? Then I'm going to scroll back to page 1 here. Then it kind of defaults to the language where it says, if escrow company or recorder's office is closed on the COE date, COE shall occur on the next business day that both are open. So if that falls on the weekend, Saturday, Sunday, it would go to the Monday or Tuesday if there's a holiday Monday, that sort of thing. So regardless of the calendar days piece, that part does start rolling. Does that make sense? Notice, cancellation. These are all boilerplate things. Notice I want to touch on though in particular, because I know you guys get frustrated with us when we're reviewing your contracts and we're flagging things like the phone number, the address is not filled in, or your email's not filled in, or the license number, that sort of thing. So first of all, those are disclosure items. Second of all, TRID, if there's financing, that could be a requirement for the lender. So that's why that was even included way back when. But also, if you read this, is that notice is sent to whatever's on those lines. So if for example, you don't fill those out, who are they going to send notice to? If the title company is sending out those CC&Rs, the title report, a notice between the parties, that kind of thing. It can be a challenge if you don't have that filled out properly because of this here. So I hope that makes sense. But if you're not filling that out, or you're using a different email and they send it to your old email, not a good enough excuse, because you should have written in the new one, you know, or whatever you're using in that those lines of the contract, or your phone number, or, you know, that kind of thing. So just be really careful with that. It can be a bigger issue than you realize. Of course, always having the parties initial this section is very helpful. Obviously, it's for your protection. And then the terms of acceptance. And then again, filling out this section appropriately and filling it all out. And I know, again, I know you guys get frustrated when we're flagging this box wasn't checked or that wasn't. And none of it's an issue until it's an issue. And, you know, at our risk management meeting next week, we're going to talk a lot about that. But unfortunately, in the legal situations we've been involved in, and even though that checkbox may not be related to the ultimate issue that might be between the parties, the attorneys, I guarantee you, will bring it up, and they will use it against you as an agent to say, if you weren't careful with this, why were, you know, does that show that you're not careful with all these other things you're saying you did or didn't do? Does that make sense? It's critical for other reasons than you realize sometimes. And so it's just really important as you're filling out these contracts to take your time, fill them out properly, fill them out completely, all of those lines, and to not just run through it really quick. It's important the clients understand all of these terms so that when things happen, you can refer back to them and say, remember when we talked about the other party didn't fulfill this term? It's not a breach, because that's what they automatically think. It's, we have to give them 3 days notice. And when you prep them that way and set that expectation, it can avoid so many challenges for you down the road. So as an agent, so Stephanie, just on a question regarding expiration of cure on weekend or holiday. Does that also apply to loan docs to title? I don't think so, because technically the buyer can still sign and deal with that on the weekend. And I think, I guess, let's look back. It's a good question. Stephanie asked, on the cure notice, expiration of the cure on a weekend or holiday, does that also apply to loan docs for title? Let's go back to that language. So the way it reads is actually that no later than 3 days prior to close of escrow, buyers shall either sign all loan docs. So they can still sign on the weekend. So the weekend is still the only one that really moves to the next business day is the close of escrow, because of the recorder's office, if that makes sense. Because all these other things they can conceivably do on a weekend regardless. James said, shows a trend to pay attention to pertinent details. It does. There's a lot in here. You know, I joked for years that every new clause or page of the contract is because of a lawsuit that happened somewhere or challenges that came up. And all of these things, all of them are important, because again, when something doesn't go right, this is what we have to refer to and back to. And if the clients don't understand that, they start pointing fingers, and we are obligated to really explain these things to folks. Is there anything in here you guys want me to cover any more? I mean, we're going to be talking about a lot of things next week as well at the risk management meeting, and particularly with having our attorney there, we're going to cover some more of the BINSR changes and the fact that they're writing in that statute about the handyman exemption. I know a couple of years ago when he was there, we really kind of hounded him about that, but I wanted to go a little deeper on it now, because we're all going to be responsible for explaining that to our clients on what repairs require a licensed contractor or not. So I'm going to have him touch on that quite a bit next week. But is there anything else in the purchase contract you guys want to talk about? One other quick thing before everybody jumps in, but the additional clause addendum, please use that. You know, I've mentioned it a million times, but non-refundable earnest money, for example, you can write that in and it's fairly clear. And even if you say that it's, you know, non-refundable for any reason other than seller breach, that sort of thing, okay, that's fair enough. Except what happens with risk of loss? What if the house does burn down or get hit by a monsoon, or, you know, or have severe damage, that sort of thing? The non-refundable clause in the additional clause addendum addresses that, so that again, if that were to happen, it's covered and nobody's wondering, well, they took my money, but I couldn't close on a house that didn't have a roof, or, you know, that was half burned down, or whatever the situation is. So again, just make sure you're using that in every case you can, because those clauses are all vetted by attorneys and committees who spend days and weeks and hours on them, making sure they cover everything so that everyone's protected in any event. Which agent completes? Okay, so yeah, Linda, I agree. There are some things that, I mean, the contract's not perfect, and there are definitely places in it that I believe have some holes. But I think they do a pretty good job. I mean, I think they do as well as they can. It's just really difficult to cover, you know, when you're on these committees, if you've ever sat in on one, it's hard to think of every single scenario to cover everything that is even possible. Because we all know life happens, and it's in 27 years, I see something new every day. So, which agent completes the seller info on line in 9? I would say, I think it's the seller's agent. But I think it's helpful to put the agent's name in there if you can pull that from MLS or wherever you're pulling it from, and include that in here on their behalf when you're writing the offer. But I do think that's a seller's agent responsibility to complete that, because there might be a team member that's going to be included there, that sort of thing, now that they have those couple of lines that maybe wasn't in MLS, and maybe now they're adding a TC or someone else who's going to be helping with that transaction, because maybe they're going to be gone and they didn't expect that when they put it in MLS, that kind of thing. And Linda said, oh yeah, it was 4 pages without all the added addendum now that are required. Yeah, it's a lot. It's a lot, but it's all important, and it's important to go over all of it with your clients in detail. When things happen, it's so much easier to go back to them and say, remember when we discussed, or remember when I pointed this out, because they tend to forget. So, and if you do it the same every single time, it really helps. I remember a situation, I was in a mediation one time, and a client was making a claim that an agent didn't explain something or told them something that that they didn't include in their contract, and the agent pulled out a binder with, you know, the last 100 contracts they had written, and they said, I've never written that in. Why would I tell you that it would be any different? You know, and that wasn't a listing contract in that case, but, you know, showing that you're consistent in the way in your practices and what you do, and when you explain things, is going to help you, you know, if you were ever having someone make those kind of claims or have a challenge down the road. We are 9:59. Any last minute thoughts or questions, or anything I didn't cover you guys want to talk about? You guys are all quiet. Everybody's muted. You're welcome, Andre. Linda, that's a great tip. She said when when she got her license, her sales manager recommended reading 1 page of the contract every day and make notes of anything you don't understand. That's huge. I agree. I still go back and just reread certain sections. And when I get questions, I tend to say, I think this is the answer, but let me get back to you until I can reread it. Because even as many times as I've looked at it, there's always going to be those things that I'm like, I need to reread that language, you know. It's just really important. So
thank you, Shannon.
Great tip. You're welcome, you guys.
I did have one quick question, and I'm just curious about everybody's opinion, especially like experienced agents. If you get a contract and, you know, on your listing, and they don't put your office address, you know, like on that last page, is anyone just fixing that, like after they do the offer, or just like doing it, or do you actually, like, do they go back to that agent and say, can you, you know, my address is so and so, can you please fix it ahead of time?
So are you saying, like, if you're the listing agent, for example?
Yeah.
When you receive that, you can fill that in. Or you're saying if it's wrong?
No, like if they just left it blank. I mean, I know I can.
Yeah.
Yeah.
You
Okay.
can fill that in as the listing agent.
Okay. Somebody said they updated. I just fill it in. Okay. Okay, I was
Yeah,
just.
and if it's wrong, just, you could always line through it, have your seller initial it, because then again, that's the seller section. Buyer section really kind of does stop at section 8 in terms of the things that when they're making that offer, that they're responsible for completing.
Okay.
Yeah. Yeah, Danielle said, it sounds like most people are all saying they all just fill it in as needed.
Jennifer said I do it, but I'm not an experienced agent.
Yes, she is.
Jen, I love you. You're hilarious.
She's got she's had some tough ones. She's gotten plenty of experience.
Right? I'm telling you.
Yeah.
I know that's right.
Veronica, I'll get you a copy of that recording. We'll get that out to you guys. Alex will have that, and I think he'll post that, but I'll make sure you guys get a copy. I'll make a note.
Okay, thank you.
And then just, again, remember next week, you guys, the risk management meeting, we're gonna have our attorney there. It's a great time to just get as many questions to him as we can and get all the answers we can from him. So I really encourage you, make sure you're there for that, because that's a big one. Everybody good?
Thank you, Shannon.
Thank you, guys. Have a great day. If you need anything or have any questions that you want to come back to me in private, feel free to give me a call. All right. Thanks, guys.